Hey everybody, this video is sponsored by OKCoin Crypto Exchange. Why pay ridiculously high fees to Coinbase, Kraken, and Binance when you can use OKCoin, which has the lowest fees, guys? So if you want to save money on buying and selling and trading crypto, definitely have to use OKCoin. Sign up, link in the description. Hi everyone, welcome back to the Thinking Crypto channel. I have attorney John Deaton with me, and we're going to go over the Ripple XRP lawsuit, the William Hinman deposition, and as well as William Hinman's speech in 2018 that highlighted Ethereum is not a security. John, great to be speaking with you again.
Thanks, Tony. Thanks for having me. I appreciate it, man.
So, John, last week we had the hearing, and the outcome, the ruling was William Hinman has to sit for a deposition. What are your thoughts on this, and do you see this as a win for Ripple?
Yeah, I see it as a huge win. As everybody knows, the SEC fought this very hard, and even implied by, and I know Jeremy Hogan stated it on one of his videos, that the attorney was like, well, if you order the deposition, we'll have to think about what our next step is, or something like that. So, that implied, are they going to try to do some kind of appeal to Judge Torres, that Judge Netburn got it wrong? So it's significant. And I know I tweeted out today because I saw an article by Cointelegraph that said, oh, another small victory for Ripple in this case. This isn't small. This is huge. The two biggest victories, in my opinion, have been the Bitcoin, Ethereum, XRP discovery, that those documents, I know they haven't been turned over yet, but just the fact that the judge ordered that internal memorandum, opinions, things that that may have been said by one of the commissioners, such as Hester Parse, that's fair game. As far as it being discoverable, it's always subject to privilege and the deliberative process and all of that, but that's huge. And now this particular deposition is huge because it gives Ripple an avenue, not just to find out why Bill Hinman did what he did, and not just to get into the conflicts of interest. I'd actually tell everybody they'd be surprised to hear me say this, because I've been someone who has been very public about criticism of the conflicts of interest, the 15 million while you're at the SEC, gratuitously giving a speech about Ethereum and giving Ethereum clarity while your law firm is on the board of the Ethereum Alliance, right? I've been very vocal about that. But what this allows, I would tell people that if I'm Ripple and I'm Ripple's attorneys, I'm viewing this Hinman deposition as the conflict of interest issues as being sort of at the back burner, more so being able to get information from Hinman that's going to support their summary judgment, right? Because the judge stated that the Bitcoin and the Ethereum documents and discovery is relevant to help the court decide the Howey factors as it applies to XRP. What that basically means is if XRP is the functional equivalent to Bitcoin and Ether as far as decentralization, as far as structure and all of that, it's game over, they win. So this Hinman deposition gives them an opportunity to walk him through it. And as we go on in this video, I think it'll be more clear of what I'm getting at as we go on. But it's huge victory for Ripple, in my opinion.
Absolutely. And, with the deposition, and we talked a bit about this, potentially three outcomes. One, the SEC doesn't allow it to happen, and maybe they get ahead of us and say, hey, we don't want anything else to be said about this, and trying to save face. And they don't allow the deposition, but they come up with some sort of settlement with Ripple that's favorable to Ripple. Two would be he pleads the fifth. He doesn't say anything. And three, he does testify, and he says some positive things and things that Ripple maybe can use and learn about in moving forward. What are your thoughts on those three scenarios? If you can go one by one, please.
Sure. I think let me take the fifth first. Okay. I don't believe that Bill Hinman will plead the fifth at a deposition. If he does, it would be such a stigma against the SEC. And there is an implication there of criminality. If you plead the fifth at a civil deposition as a civil servant, right? The implication is an admission that, hey, there really was not just the appearance of a conflict of interest, but I did something bad and I'm not going to admit to it and I'm not going to incriminate myself. I would suggest that if he were to plead the fifth, that in and of itself could launch an inspector general investigation into all of this. And so I just don't see that happening. Now, for that reason, there's a second reason. The second reason is the SEC can tell him, don't answer that question because it goes to the deliberative process. Don't answer that next question because it goes to the deliberative process. So they can sort of stop him from incriminating himself anyways by invoking the privilege, right? So they can run interference that way practically. So that's just, maybe I'll eat my words if it turns out otherwise, but I just predict that's never going to happen. So now, if he has information that is extremely helpful to Ripple in their fair notice defense, and you couple that with the documents that they've refused to turn over. Let's remember that Ripple's attorney, one of them, stated to the judge that not one single document has been turned over based on her two orders, and that the SEC is claiming every single document is privileged. And so it's hard to imagine that every single document's privileged, right? And so the implication there is that there's stuff in there that is very helpful. It could be something from Hester Parse or Elad Roisman that says that, they don't think XRP is a security. Now, I'm speculating, but I have to, and you have to, because we don't have the documents in front of us. And so the SEC is concerned about two things. One is this case. That's the short game. And then there's the long game, which is if they receive a bad decision in this case, for example, let's take the fair notice defense. If that wins, then they're looking at facing that defense from every cryptocurrency, digital asset they go after, right? We know that Library, they filed a case against Library. Well, everything Ripple's doing is going to be used that's successful that Ripple does. Everyone's going to try it. And so if they believe that these documents in Hinman's testimony is game over, then yes, they could go to Ripple and say, we want to settle. Or they could say, we're not going to do it. We're not going to turn over the documents and refuse to turn over the documents and go to the deposition of Hinman and instruct him not to answer every question. And then Ripple would go to the judge, and then the judge would order them to do it, or the case be dismissed with prejudice. And then that could be an out for the SEC, where they just refuse to do it. The judge says, you got 2 weeks to comply with my last order. And if you don't, I'm going to dismiss it with prejudice. That's called a conditional order. And they say that's our out because they don't want the big picture damage that could go on with their ability to regulate digital assets going forward. And then potentially appeal that judge's decision and try to go down that road. It's sort of like, if you're going to lose, you kind of lose intentional, and then you can still muck things up by doing an appeal or things like that, and then negotiating a settlement. What would be interesting, Tony, in that scenario is if they talk settlement, there's not a lot of incentive for Ripple to settle unless Ripple really gets what it wants, right? And that would be a declaration that XRP itself today is not a security, it's not an investment contract, period. And then they accept some kind of small fine. A small fine for Ripple would be like $20 million or something like that. And the SEC can claim that they got something out of this prosecution and they can fight another day. And then finally, I think your third scenario is, okay, he does testify. And there's two things that can happen. And what's interesting is that I'm sure that one of the lawyers for Garlinghouse or Larson will be sort of the bad cop, right?
Yeah.
They're going to go down. One of them will be picked to be the one that asked him about the money that he collected, the 15 million, the conflicts of interest, even the question of why. Why did you give the speech? Why single out Ether, right? XRP actually was the second cryptocurrency after Bitcoin. Why did you decide to give Ether? And does the fact that your law firm represent clients for Ether, the fact that your law firm's on the board of the Ethereum Alliance Foundation, all of that, that is one avenue that they're definitely going to go into. But Ripple has an opportunity to get very valuable information from him and apply those things to this case, and then use his testimony in support of their summary judgment. And what we'll do is we'll go through the speech a little bit for everybody, and I'll point that out. So that's one thing that can happen. The other thing, of course, is he could testify and say, I don't remember a lot, right? So, for example, everyone knows by now that he met with one of the co-founders of Ethereum 1 week before he gave his speech. So obviously one question is, and it's not privileged because this person doesn't work for the SEC. So it is, what did you guys talk about that week? Who was it? Was it Vitalik or was it one of the other co-founders? What did he say? What impact did what he said to you have on your speech? Did he get a draft of your speech? Did he write any of it? Did he approve it? Did you say, here's a courtesy copy? Is there anything I'm saying that's inconsistent with, your technology or the current status of Ethereum? Those are very big things that could come out. And he might say, well, I don't remember. It was a long time ago, right? Now, a lot of people have said, well, what if he does that? If he does that, the judge is going to find out and know about it, right? He's not going to be able, he's admitted that this speech was a big deal, and that there was a lot of attention that it got after he made it, both in the market and in the media. And so
sure,
I think that if he goes down that road of I don't remember anything, even that plays in Ripple's favor, because it just goes to, something suspect here. You know what I mean? But who knows? He could end up being the star witness for Ripple, believe it or not. A lot of people think, they don't think that, but it potentially could. And we'll get into a couple reasons why I think that here in a minute.
So we saw the deposition got, if I'm not mistaken, pushed back to July 27th. I believe tomorrow we should hear from both parties by 5 p.m. Can you walk us through that process that are both sides currently negotiating or coming up with agreeing upon questions, or what's actually happening there?
Yeah, I mean, Ripple's never going to say, okay, here is a list of all our questions and, which ones are you going to object to? Not like that. But what they talk about is scope. So, for example, the SEC, Ripple is going to say, okay, let's get through the easy stuff first when they're doing this meet and confer. Ripple's going to say, you agree, right, that any question we ask of Bill Hinman of who he talked to that isn't working or wasn't working at the SEC, you can't claim privilege and you can't claim deliberative process or pre-decisional decision making and none of that stuff. So whatever he said to the co-founder and the co-founder said to him, if he spoke to people at his law firm, you agree with that, right? And then they would have to say, yes, we agree. Then the question would be, well, I'm going to ask, let's say I'm Ripple. I would tell the SEC, I'm going to ask who, what, where, when questions that don't ask what was said. So it can't be privileged communication. I'll give you an example, Tony. Let's say that I'm your lawyer and I represent you in something and you're being deposed. Mm-hmm. The other side could say to you, how many times did you meet with Mr. Deaton? Right? And if you say, well, I met with him 5 times. Now, they haven't asked, what did Mr. Deaton say to you? Because that's attorney-client privilege. So they can ask some kind of, factual question. So, for example, what they need to find out is, I would ask this question: how many drafts was there for this speech? And who took part in writing the speech or approving the speech? Again, I'm not asking what did they say, right? So I'm going to say, did any of the 5 commissioners, did any of them review this speech before you gave it? Didn't ask what they said, didn't ask what they thought. I just want to know. All right, did Hester Parse review it? Just as, let's single her out, for example, or Elad Roisman, did he or she review it? Okay. Is the SEC going to instruct him not to answer that question? See, if they are, then they're going to have to go back to the judge. I don't view that as privileged. Now, the next question would be, of course, let's say hypothetically Hester reviewed it. Then, of course, if they say, what did Hester say? Then they could instruct him not to answer it, right? But just the view, for example, we all know, this is what I mean. Like, here's an example I just thought of as I'm talking this with you. We all know that Hester and Elad Roisman recently came out and gave some public statements that said that the SEC continues to not provide clarity in the cryptocurrency digital asset space, right?
Yep.
So when Bill Hinman's on the stand under oath, I would ask, did Hester or Elad review this speech? If they did, I might not be able to ask, what did they say? But we know what they say today.
Yeah.
So we know what they probably said, right? So now we can bring that and tie it together and say that, in 2018, Hester Parse may have reviewed this speech. We don't know what she said to him, but we know that in 2021, she's still saying they're not providing clarity. So this speech, as much as they say was trying to provide clarity, actually caused more confusion in the market. There's all different ways to play it, is what I'm getting at. And so those are the types of things that they're talking about right now to figure out, what are you objecting to? At the hearing, it sounded like the SEC attorney was going to object to everything, right? We're just going to instruct them. I think they're not going to go down that road because the judge would, cut them down at the knees, basically. And so that's what's going back. I ultimately predict that Judge Netburn will have to rule on what is going to be considered deliberative process or not deliberative process, because this really is a very convoluted concept, right? Which is, they're claiming that Bill Hinman's speech was about his personal opinions and not official. Well, if it's his personal opinions, then why would what someone told him be part of the deliberative process of the SEC?
Right.
Right. That's inconsistent in and of itself. Well, it's not official statements of the SEC. It's his personal opinion. But we're not going to let you find out what someone else at the SEC said to him, because it's part of the deliberative process. Pre-decisional is what the SEC attorney kept saying. And if you remember, Judge Netburn said, you keep saying pre-decision, that implies there was an official decision. You know what I mean? And so there really is this inconsistency with the SEC's position. And I think that the judge is going to have to rule on some statements by other SEC personnel, whether or not Ripple can actually ask Hinman those kind of questions. And so I'll be surprised if they don't go back to the judge saying they need her to rule on something.
And what's interesting, and we're going to go through the speech, of course, the SEC is hosting that speech on their website. So any random person landing on the site will think this is a something put out by the SEC, not William Hinman's opinion back in 2018. It would just be like, oh, this is the SEC's position.
Yeah, go to the video. I'm sorry to interrupt you, Tony, but go to the video where they have his, I'm saying you don't have to now, but everyone, if they pull up his speech, it says SEC, Director of Corporation and Finance, it's held out as the SEC. And then we all know that he continued to say, this was the first time we spoke out on Ether. Well, who's we, right? We is the SEC. Right. And the SEC like to say, we only provide guidance through risk alerts and enforcement actions. Everything else is personal opinions of the commissioners. They help develop the market, and they help develop the market sentiment, the market perception. And so this speech was a huge, huge, huge thing. And Judge Netburn, her decision is the right decision. It's a very unique circumstance. And also the fact that the SEC is retroactively going back 7.5 years after allowing this to happen, right? People got to remember, in 2017, the SEC was very aggressive against the ICOs. Yeah. And they shut it down. I mean, Telegram got shut down, and you got King, and you've got EOS, and you've got all of these prosecutions, and Ripple is left alone. And so it's a very unique situation to say, we're going to go back from in 2020, when they filed the lawsuit, late 2020, at the end of the year, we're going to go back, 7.5 years and say that every XRP ever created, including the ones today, including in the secondary markets from people that have nothing to do with Ripple, that all of that XRP is unregistered securities. And so when you take that kind of overbroad approach, you're going to get rulings like this that allow these Ripple and these two executives, to defend themselves against this kind of, claim.
And in fact, John, I remember in 2017, Coinbase had not listed XRP, and I think it was their CTO would go on CNBC alluding to securities laws. He wouldn't outright say XRP is a security, but he's like, we go through the process of reviewing if coins fall within securities laws and things like that. And everybody was like, why isn't Coinbase listing XRP? Now, they eventually did, right? But not that year. And to your point, where was the SEC?
Right. And we know that it's 2019 where Coinbase went to the SEC and said, we're going to list XRP. We've made a determination, and the SEC didn't do anything to discourage that. Right. And let's face it, if I'm the general counsel for Coinbase, even if I was conservative like they were back then at 2017, 2018, 2019 comes around, I'm going to say, listen, if the SEC thought XRP was a security, they'd have done something by now. I mean, that's just common sense, right?
Right.
The way I think would have been, well, they went through these aggressive prosecutions of ICOs. They left XRP alone. I think it's safe to say that they're not going to, after the fact, come back and say, oh, for 7.5 years, you've had an illegal, unregistered offering each and every time that XRP has been traded around the world by no matter who trades it. And it's such an absurd claim that it is a unique situation where Bill Hinman's going to have to testify. And so, the only thing that I regret is I don't get to participate, or at least I don't think we'll ever be privy to it, at least now. The deposition will be sealed and the public won't necessarily get to review it all. At some point, there'll be certain parts of it that would be released, but at first it's going to be protected so that they can go through it with a fine-tooth comb of what can be released to the public about what's privileged and all of those things.
Sure. So on that note, how about we go through William Hinman's speech from 2018, which of course is hosted on the SEC's website, titled Digital Asset Transactions, When Howie Met Gary, and in parentheses here, plastic. So William Hinman's speech from June 14th, well, at least I guess what's published on the website, June 14, 2018, remarks at Yahoo Finance All Market Summit Crypto. So John, where would you like to start? I think you had mentioned the opening paragraph, right?
Well, what I want to do is let everybody know that what Ripple's lawyers are probably going to do is they're going to walk him through this speech line by line. I mean, they're not going to necessarily go sentence by sentence, but you get my point, because let's start even with what you've highlighted here. And I would recommend all XRP holders, listen, this is like 5 pages long. Get on it, read it. You're going to get mad at certain sections that we're going to go over, but this is how he could be used, despite all the conflicts of interest, as the star witness for Ripple. So, for example, even this third sentence, right? It says, this event provides a great opportunity to address a topic that is the subject of considerable debate in the press and in the crypto community. So that sentence alone, you're going to get him to admit that one of the reasons he gave this speech was because there was confusion in the market.
Yeah.
And what's a security, what's not a security. And so he stepped out, even though it's his personal opinion. It's on the SEC website to this day. So it's not like they've ever retracted it, and get them to admit that in 2018, there was confusion and debate in the crypto community market. What's that go to, Tony? What defense does that go to for Ripple? Goes to that fair notice defense.
Fair notice, that's right.
Right. I know I put you on the spot, but
I'm a bit slow tonight.
No. That's what I'm getting at, man. That goes to it to establish that fact. And so that's how, what I mean is a small example of using him as a witness. And then let's go down to really it's the next sentence where we says to start, right? To start, we should frame the question differently. Now get this, and focus not on the digital asset itself, but the manner in which it is sold. That's basically what it's saying. Now, remember, XRP holders' motion to intervene, the only reason we're there and knocking on the door of the court is because the SEC has stated, and anyone that wants to refute me, because there have been a few people in social media, all they have to do is go to the SEC's motion in opposition to our motion to intervene. And on page 24 of that memo, the SEC says that sales of XRP, including sales within the secondary market, are representations of an investment contract with Ripple. That's basically what they say, which means XRP itself is a security, right? Something that's never been argued. And here we have Hinman saying that the focus isn't on the digital asset. And then it gets later, we're going to come across this again, Tony, where that's significant. So this is an example where you get Bill Hinman to admit that XRP itself is not the security. The security is the manner in which it could be sold.
Right.
And so you start building the record for your motion and summary judgment, or for XRP holders, if we were to get into the case and be allowed to be amicus with participatory rights, I would be on behalf of the 18,000 XRP holders filing what's called a declaratory judgment, where I'm asking the court to declare as a matter of law that XRP itself, the digital asset, is not a security. You know, somebody can package it and market it just like Bitcoin or Ether or gold, but itself, the asset is not a security. And so that's how you go through here. So that's something good. And then, of course, he asked the question where you go down where it says, can a digital asset that was originally offered in a securities offer ever be later sold in a manner that does not constitute an offering of a security, right? And so that's basically the question he posed, which now Ripple's lawyers will get him to admit that, say, even if in 2013 to 2017, XRP was a security, that doesn't mean it was in 2018, 2019, 2020, and 2021.
Right.
You walk him through it because you're building the record from someone so significant from the SEC itself to build your record for your summary judgment. And then, you know, he just goes on to say that that a digital asset that represents rights in an enterprise, then of course it's always going to be a security. Well, XRP doesn't give any financial interest in the Ripple itself. And this is where, you know, we would bring out the fact that you could go on Uphold and link to, for example, and buy shares of Ripple, the company, with your XRP wallet. You know what I mean? So you're using XRP to buy real shares of Ripple, the real security. And so these are things that you build as you got him on the stand. And so another thing to go is, let's go to where it says, unfortunately, there are cases of fraud. I don't know if you can find it quickly, but it's going to be before you get to, no, it's well before 9. It's like before the number 4.
Let's see. Is it between 3 and 4?
Yeah, it's before there. It's anyways, it's not the point I was going to say. It's not that important. People can read it, but it right here it is. Unfortunately, at the very top, unfortunately, there are cases of fraud, right? Well, you point out the fact on the record here that there is no fraud in the Ripple case. There's none alleged. After 2.5 years of an intense investigation into Ripple and XRP, the Securities and Exchange Commission, after 2 years, could not find one instance of fraud or misrepresentation. You know, and so then if I'm asking Hinman on the stand, I'm going to say that's why in 2017, when you all were going against those ICOs, you left Ripple alone, didn't you? You know, ask them questions like that to point out the fact that you get out of him that in 2017, there was an aggressive enforcement actions against ICOs. Bring out the Telegram case and how Ripple and XRP are not like that in any way. And so you're distinguishing all those enforcement actions where it was proper to distinguish the one that we have today, which is improper. And so that's what I mean. You just go line by line through here, explaining to them. Then, of course, if you go down just a little bit more where it says, but in many cases, I don't know if you can, right here, right in the middle. Yeah. So like, read that part. But in many cases, the economic substance is the same as a conventional securities offer. Funds are raised with the expectation that the promoters will build their system and investors can earn a return on the instrument. Guess what that sounds like? That sounds like Ether.
Yep.
Right? That's an ICO. That's when you bring out the fact that later in this speech with Hinman, he says, if you set aside, I think he uses the word put aside, putting aside the fundraiser of Ether, but we're going to say, well, let's not put it aside during this deposition. And during this deposition of Mr. Hinman, we're not going to put that aside. We're going to talk about that a little bit, and then point out the fact that Ether meets the very definition that when they raised $18 million from 9,000 people across the world, the Ethereum blockchain had yet been developed. Can't say that about Ripple. Can't say that about XRP. XRP ledger, fully functional, right? Before Ripple ever existed. So you point these things out because the judge is going to see these things. Right. You know, it's not like a winning argument to say, well, it's this thing called selective enforcement, right? Where they give a pass to one company and they don't give the same pass to another. That's not a winning strategy. It might be unfair, but that doesn't mean Ripple's going to win. But you still raise these things this way so that when the judge is reading the transcript, there's something like this just doesn't set right. Like, why did Ether get the pass? Why did they set aside the fundraising event? Why? And the more times the judge asks that as she's reading the transcript, why, the more favorable it's going to play out for Ripple. Why did Clayton authorize it this last day?
Sure.
Why did he not wait for the new administration and Gary Gensler and them make the decision? Why did the director of enforcement leave 3 weeks after filing the most significant enforcement action? Why not listen to Grunfest when he warned you that millions and millions of people are going to lose billions and billions of dollars? You know, and so it just starts building that record. So just for people there, they've heard it. If you go down the next paragraph, he gets into the SEC v. Howey case. And I want to point something out here for people, right? He basically, this is the test. That test requires an investment of money in a common enterprise with an expectation of profit derived from the efforts of others. That's the Howey test. What it really is tragically sad here is that the Ethereum ICO meets the Howey test better than Howey meets the Howey test. Now, a lot of people, Tony, are going to say, "Oh, Deaton's exaggerating. He's being hyperbolic as he's trying to make a point." No, because there was actually a dissenting opinion in the Supreme Court case of Howey, where the dissenting judge said, "Listen, some of the investors in the orange groves, some of them did visit the orange tracts. Some of them did want to pick their own oranges and sell their own oranges. Therefore, they weren't relying on the efforts of only the Howey company." But, and so there were some distinguishing factors here with Ether. You simply said, if you got in early, you gave a Bitcoin and you got 2,000 ETH. And you sat back, and 1 year later, you did nothing. And the founders of Ethereum built the blockchain for Ethereum 1 year later. And then it started trading, and markets went up and maybe you made some money. That is the very definition of an investment contract under Howey, because they did nothing. Whereas opposed to XRP holders, we can stake our XRP and we can collect interest. We can take a fiat loan using our XRP as collateral. We can use XRP to buy groceries on our debit cards and things of that nature. Many of the people like you, content providers in the community, may acquire XRP as a form of payment or tip or anything like that for you providing great content. And so there's so many distinguishing factors that we have that you can walk through Hinman and build, the record. And so if you go down he just goes in later to I'm not going to go through everything. Obviously, he goes into ICOs, but let's get to where they give me 1 second to if we go to now just before right after number 9. All right, and this is where we get to the sentence starts off as and so. Go up, scroll down a little bit before that, just so they get some context. If you can go up a little bit more, right there, and so he starts off the speech, or not starts it off, but he's at this point in the speech, he brings up Bitcoin, right, and no central third party, and the decentralization, and all of this, and that there's no way to apply the federal securities laws to Bitcoin because you don't have that central third party, right? Sure. We don't know who Satoshi Nakamoto is, and by this time it is much decentralized. So then now is where Hinman's on the stand, and this is where you really get into the nitty gritty with him, and that's when we get into where. First and foremost reason, why did he bring up Ether? Why Ether as opposed to anything else? Like, just find out what was the motivation. Well, if he says something that goes to the conflict of interest, Ripple can use it. If he says that it was meant to clear up or try to provide guidance to the industry because of that mass confusion, Ripple can use it, right? They can use it to talk about this lack of clarity. Now, the reality is that this speech caused even more lack of clarity, and Ripple will be able to show that. And so it just gives more teeth to the fair notice defense. But then he goes into, this is what people are going to get upset about, because here it is. He says, and putting aside the fundraising that accompanied the creation of Ether, because you can't say that it's not. It meets the very definition of Howey. We already went over that. But here, based on my understanding of the present state of Ether, okay, stop the deposition, right? I'm not going to go any further. I'm going to ask him, based on your understanding, what is the basis of your understanding?
Yeah.
What did you learn that built you this understanding or provided you this understanding? What technical manuals did you review? Did you compare the Ether blockchain technology to any other technology? Did you confer with anyone? Oh, wait a minute. We know that you met with the co-founder of Ethereum 1 week before. Did the co-founder, who was he? Get that information out. Did he review this speech before you gave it? Was he the one that provided you this understanding that formed your opinion as we move on next in the speech, where he goes on to say that the Ethereum network and its decentralized structure. So now we ask him, what about the Ethereum decentralized structure were you talking about? Name me some specific factors of the decentralization of it that you were relying on. Did the Ethereum co-founder give you that information? Now, what's great here is that whatever he says, Ripple can use it one way or the other, right? And so let's say he is able to say, well, I talked to this person and that person, and my understanding was because there were, it was decentralized based on there was not a controlling third party, right? Well, then you can bring out, you elicit the testimony that's going to show that Ripple is sufficiently similarly decentralized, whether it's the fact that the validating nodes on the XRP ledger that Ripple is, less than 6%. The fact that Ripple even objected to some change and they were overruled by the XRP, the validating nodes and the other participants on the ledger. There was a vote and Ripple lost, and that proves the fact that David Schwartz said that it could be voted that the escrow be burned even if Ripple objected to it. The Ripple's attorney is going to have to be sufficiently aware of the technology of Ripple to elicit testimony from Hinman that basically say everything you just said about Ether's decentralization applies equally to Ripple. Applies equally to XRP and the XRP ledger. Right. And you bring that testimony out one way or the other, because then you use this testimony and then you get the testimony of, someone like Hammertoe, right? How great would he be, right? To provide an affidavit or testimony on, when he schools people on Twitter about the fact that the XRP ledger is actually more decentralized in many aspects than either Bitcoin or certainly Ether. And so that's what I mean is you just stay with him. I could spend 2 hours just on this one, sentence of asking him questions of everyone you spoke to, how many drafts, who participated, who reviewed, did the chairman review this, and even though they call it a personal, his personal opinion, you can get testimony out without violating the privilege. So for example, let's say hypothetically that it comes out that all 5 commissioners reviewed this speech, right? You can't ask, what did they say about it? The judge isn't going to allow that. Sure. But you want to know what you do? You bring out the fact that none of them came out publicly against it. So arguably they were supportive of what he said. Right. Implicitly by the omission. They didn't criticize it. Hester Parson, Elad, they've come out when they're critical of something that the SEC has done recently with that recent settlement. So that's how you prove things to help. But that's basically the heart of what I'm getting at when I say that the irony here is that as much of a bad actor as I believe, or you believe, or many XRP holders believe Bill Hinman is, he could end up being Ripple's best witness to prove that everything this man said in 2018 applied arguably equally or more to XRP, right? And that's where the debate's going to be. And this is where I would love, because I think it's in the court's best interest if XRP holders were allowed to participate, because, something that hasn't been brought up to the court is that Jorge Tenrero and the SEC attorneys, they make a big deal about, Tony, about, well, their ODL product, it didn't take off until 2018 when one customer, money transmitter, right, was experimenting with it. And so it didn't have any utility. It was a failed project and blah, blah, blah. Well, it needs to be brought out the fact that Ripple chose to disrupt a half a century old banking system that was built on friction, right? Where you get fees, where you're going to transfer money and charge the person 9%. And so you're trying to convince the banking system that, hey, we're going to do away with those fees, and this is a better long-term approach. And that disruption is not going to take, it's not going to happen overnight. It's not going to happen in a couple of years. It's going to take a while. But the thing about it is, while Ripple was trying to do that, I keep saying on Twitter, while Brad Garlinghouse gets up and says XRP wasn't meant to pay for your coffee. Well, James Rule XRP was paying for his coffee at that time with his debit card. And so we would have an opportunity to get into this decentralization, this open, permissionless, distributed ledger technology that's not limited to what Ripple's doing. So while Ripple's trying to develop this use case of cross-border payments with the banks and the money transmitters, other developers and the XRP community is building out these other use cases. You know what I mean? And so, but I gotta believe that if Hinman testifies, ultimately it's going to play in Ripple's favor. It's just a matter of what degree. Is it going to be a home run? Is it going to be a grand slam? Is it going to be a single or a double? You know what I mean?
Absolutely. And one question I want to ask you, Jay Clayton was the chairman at that time, and Hinman reported to Jay Clayton. Do you think at any point Hinman may try to pass the baton to say, you'd have to speak to Jay Clayton about that, and then Jay Clayton may be up for a deposition? Any chance of that?
Yeah, I mean, I think that he's locked into this personal. Like, this was my personal opinion, right? So I don't think he has enough wiggle room to say, well, Clayton, is the one, because he directed me to give this speech or anything like that. But I do think there's no doubt that Clayton is on their witness list. I think Hinman, believe it or not, is the more important witness for Ripple because of this speech and its impact, that it had. And so I wouldn't be surprised to see that they try to get Hester Parse as a witness. You know what I mean? They don't necessarily need her to testify live because they get to use all these statements. But think about the fact that in 2018, in Bill Hinman's third sentence of this speech, he says, hey, I'm giving this speech because there's considerable debate about what is a security and what isn't a security as it relates to the digital asset space. And you fast forward and they give the speech on Ether, and then you bring out the fact that every single time thereafter, Clayton and Hinman were asked about XRP.
Yeah.
Jay Clayton, the thing about Jay Clayton is that we're able to show that every time he went on CNBC, he was asked about XRP. I mean, he was specifically asked by Bob Pisani, what about XRP? You've given Ether a clarity and Bitcoin a clarity. What about XRP? Well, we're not going to comment on specific products or specific currencies, but you just did, right? You just did. So now they create the confusion. And then you go with the passage of time, and the fact that now in 2021, two of the commissioners are coming out and saying that we're disappointed because the SEC continues to refuse to provide clarity to which of these digital assets are a security and which ones aren't a security, and why the ones that are, right, and provide that to the market. And so if this deposition goes forward, how, like, I think it's going to go forward, Ripple's going to be in a really good driver's seat. And I think that if Hinman's deposition goes forward, it may guarantee a victory on the aiding and abetting charges, where I believe that Garlinghouse and Chris Larson charges could get dismissed, not dismissed, but summary judgment granted as a matter of law, that the SEC can't prove that they had the requisite state of mind to believe that XRP was in fact a security. You know what I mean? Not with all of this evidence. And I think that that recent letter by Hester Parse and Elad are also big factors that help Ripple. I tweeted out that I guarantee you that the litigation team of the SEC is not very happy with them, because they're just really helping Ripple in their defense, in my opinion.
Right. And what do you think is going on with Gary Gensler? Obviously, he came in and inherited this mess that Jay Clayton left, but he's very knowledgeable about crypto. I mean, he was teaching crypto at MIT. Could it be that even if he would like to maybe dismiss this, he probably can't due to the SEC's, I want to choose my words wisely here, but infrastructure of conflicts of interest and other things? I don't know.
You know, I know that I was one of the people that thought, you know, listen, Gary Gensler is a career bureaucrat. You know, he's I didn't necessarily think he's going to come in and like, oh, dismiss the case or anything like that. But I thought that it might be considered, right? Especially if he thought that that the way the SEC went about it was wrong. But, you know, Hester stated in one of her interviews to financial media, I don't know if you saw it, but she just came out and said, well, when one administration opens an enforcement action, the next administration sort of just as almost like professional courtesy or custom and practice doesn't just come in and dismiss it. It's sort of like a taboo thing that you don't do. She didn't use those words, but that was the implication. Sure. And of course, that makes someone like me, because I'm more of a common sense kind of person. It's like, why not? Like, fair is fair, justice is justice. And I keep saying, I used to be a federal prosecutor, and a federal prosecutor is supposed to stand for justice, man. Absolutely. And there's certain questions that just don't add up. And it doesn't add up why they would file this case the way they did. Right. And to go after two executives in a non-fraud case, but almost claim fraud in the language they use in the complaint, right? That they enriched themselves, that they claim they were long, very long XRP while they were selling it, and they were like implying this misrepresentation to the public. You say those things, but you let Jed McCaleb sell. Jed McCaleb, this is going to be interesting. Maybe you could figure out, or anyone that's watching this, Crypto Eddie or any of the researchers, I'd like to know from the date that Jed McCaleb, that this lawsuit was filed on December 22nd, 2020, from that date to today, how much in dollars has Jed McCaleb sold of his XRP? Is it over 1.3 billion? Because that's what the SEC is going after, right? They're going after $1.3 billion that Garlinghouse and Larson allegedly made by selling their XRP. But did Jed McCaleb, in the meantime, is he selling $1 billion or $2 billion worth of XRP? I know he's selling a lot, and he's selling hundreds of millions, but that doesn't make any sense. If all XRP is a security, and these co-founders did something really, really bad, why haven't you issued a cease and desist order against the other guy? Like, right? That's just another thing that makes no sense to me.
So strange.
Right?
And again, to your point of how they positioned this optically, look, I was here when Charlie Lee told people he's long, and then sold all his Litecoin, and then you gonna tell me Vitalik hasn't sold any Ethereum? Oh, come on.
No, it just makes it just there's just too many things that don't make any sense. And so what to me the most interesting factor that I'd love to be a fly on the wall is if settlement is getting discussed. If you're Ripple, what incentive do you have? Like you want, when this case is over, you never want to deal with the SEC again, right? You don't want to deal with these charges. You want to go about building your business. You want clarity. And so if they just were to offer, hey, pay us 20 million, admit that, in 2013, these two transactions were a security, unregistered security sale, and we'll go back to the status quo. Is the status quo good enough, right? Unless there's some kind of affirmative statement that when Coinbase relists it, it's okay, right? We don't believe that it's a unregistered security. You need some kind of finality so that the Coinbases and the Krakens and everything can go back to relisting it and go about business. And unless they get that kind of clarity, there would be no reason for them to settle. You know what I mean? My biggest fear, Tony, is this. I'll tell you what my biggest fear is. My biggest fear is that the SEC says they're in their corner and they're talking amongst themselves, and they say, listen, we're just not going to give these Bitcoin and Ethereum and XRP memos and emails and all of that. We're not giving that up. And we're going to object to everything they ask Hinman. And if the judge dismisses the case, she dismisses the case and will appeal it. Right. To me, that's the fear I have, that where they just refuse, Ripple goes to the judge says you're ordered to produce it by this day, or I'm dismissing this case. And the SEC has their out, and then they just blame it on some reckless judge, right? The judge was wrong, and then they try to appeal that decision. In the meantime, there's no clarity, right? It's just litigation and appeals. To me, that's what I fear. And that's why I'm hoping so much that we get an opportunity to get in the case and get in the case, because we need to get to the judge to say that today's XRP is not a security, and we need that declaration. We need that declaratory judgment where the judge says, as a matter of law, the digital asset XRP itself is not a security. It's no different than Bitcoin, Ethereum, or any other commodity. It can be sold as one, but in and of itself, it isn't, so that the exchanges and everyone else has peace of mind and can go about their business. And so yeah.
On that note, the judge would have to be the one to allow XRP holders to participate, correct?
Yeah, Judge Torres, we're just still waiting on the motion to intervene. People keep asking me, what's the word? And I don't know either. all I can tell you is the courts are backed up, COVID, and now they're reopening and the docket's full. And any day now we could get notice of, she could grant it on the papers, deny it on the papers, or say that on such and such date, we're going to have an oral argument and we'll see, let Deaton present his case and let the SEC argue against it and then make a decision.
So John, just as a matter of time, just the final, I want to get your final thoughts on maybe the next month or so, just really quick recap of how this will play out. We're going to probably get some updates Monday, which would be the 19th, I believe, and then the depositions on the 27th, and then what happens after that.
Well, what happens after the deposition is, I believe the next step is going to be, well, hopefully it's going to be us, right? There's going to be something to do with XRP holders' motion to intervene. That's what I hope. But everything now is going to be geared toward the argument on the motion to strike, the fair defense, affirmative defense, and the motion to dismiss the individual defendants. Brad Garlinghouse and Chris Larson, their depositions are scheduled. That came out, right? That's being scheduled. They're participating right now. So each side gets 10 depositions in a federal court case, unless you get permission from the other side and there's an agreement, or you get a court order, you're limited to 10 depositions. And so the SEC is taking Brad and Chris's deposition. They could be taking David Schwartz's deposition. They are taking, Miguel Baez, I believe, is on their list, and several other past employees, where they're trying to, build their case. And I doubt that the only other person that the SEC would be bigger than Hinman is obviously Clayton. I don't know if they're going to be able to get Clayton. I have a hard time imagining the judge is going to allow both, right? Because what's the purpose of getting Clayton's deposition? It would be like, well, why did you file it? I mean, I don't think the judge is going to necessarily allow sort of like a fishing, what she might describe as a fishing expedition on the motivation behind the lawsuit. And so unless they can articulate something factually, maybe something to your point earlier in one of your questions to me, which is good, maybe something comes out of that Hinman deposition that allows them, to go after Clayton in deposition as well. Now, that doesn't mean that they're not subpoenaing the records. Now, maybe they learned something from the subpoena that they issued on Clayton's One River employer, right? We know that they subpoenaed records there. Sure. Now, obviously, I'm not privy to any of this. So if they learn something from there, that might create an avenue for them to be able to depose Clayton as well. You know what I mean? If they're able to prove something that goes hand in hand with the fair notice issue, that the whole purpose behind this lawsuit wasn't a securities case, it was something else. You know what I mean? Sort of like the lawsuit was the weapon. You know what I mean? But that's going to take more than what we know now. There has to be something that's uncovered, a smoking gun document or email or something like that.
Wow, John, you have so much insight and knowledge about this, and I always learn a lot when I speak to you, and I would love to have you back on as things progress and the deposition of William Hinman takes place. But thank you so much. And I appreciate your time. And if we meet up, beer is on me.
Oh, absolutely. Absolutely. But I appreciate you having me. And hopefully the next time we talk, we'll both have a big smile on our face because we got good news on XRP holders motion to intervene. But I'd be more than happy to come back, and even if it's bad, I'll come back. But hopefully I'm coming back with a big smile on my face because they deserve it. XRP holders deserve their voices to be heard. You know what I mean? And we honestly bring stuff to the table. You know what I mean? We really do. We can help the court make the right decision by just sharing, the things that we know and how we use, acquire, and what we do with our property, our XRP. And so, anyways, thanks for having me, man. I appreciate it.